Em suas 39 primeiras edições, nosso congresso foi presencial, com grande sucesso. Veio a pandemia. O desafio de realizá-lo à distância mostrou-se uma oportunidade. Aprendemos a tirar partido da internet e repetimos o sucesso. Agora, para nossa imensa alegria, o pior da pandemia parece ter passado. Assim, podemos voltar a nos encontrar. E vamos comemorar isso no maior centro de negócios da América Latina, na cidade de São Paulo, de dura poesia concreta e discreta beleza. Do ano que se comemora o centenário da Semana de Arte Moderna de 1922. Frente a acontecimentos recentes no mundo das artes, como os NFTs, e frente à perspectiva de realidade virtual e a realidade aumentada virem a fundar uma nova internet, certamente teremos muito o que discutir. Como sempre, vamos tratar de todas as novidades no campo da propriedade industrial, pois sabemos que marcas, patentes e desenhos industriais ocupam um lugar de destaque no mundo em transformação. E vamos festejar a possibilidade de voltarmos a nos ver frente a frente. Depois da experiência remota bem-sucedida, quem, por qualquer motivo, não puder estar em São Paulo, não ficará excluído de nosso congresso e poderá interagir com os presentes. Todos poderão assistir a todas as sessões simultâneas no momento que convier, pois o Congresso Internacional da ABPI de 2022 será híbrido, como os novos tempos estão a permitir, e todas as sessões ficarão disponíveis na internet como desejam os nossos associados. É um novo desafio, mas estamos confiantes no sucesso. Afinal, São Paulo sempre foi palco de imensos desafios, da expansão de nosso território à independência, do sucesso de nossa indústria à grande revolução verde que impulsiona o Brasil, e da afirmação de nossa cultura e nossas artes. A fronteira agora é no universo virtual e no ambiente de negócios que nele se constrói, totalmente dependente da melhor regulação possível da propriedade intelectual. Se preparem para as discussões instigantes do Congresso Internacional da Propriedade Intelectual da ABPI. Será uma grande confraternização. Não perca!
Boa tarde a todos. Good afternoon to all. Today, our panel will be in English because we have a very special guest, an American colleague. It's my pleasure to have you all here. For brands, metaverse is the next big thing. Sorry, got cut here. Reading my text. 1 second, sorry about that. Here we go. So again, for brands, metaverse is the next big thing for consumer interaction, brand building, and digital and real world sales opportunities. It's expected to change the way we work, shop, socialize, and live our lives. And while virtual reality is not something truly new, video games have been around for decades, offering immersive user experiences. The possibilities offered now by the technology behind non-fungible tokens, the NFTs, seem endless. The goal of our panel is to explore the parallels between the video game industry and metaverse as it relates to intellectual property, especially trademarks and copyright publicity, in Brazil, as we call it, personality rights. On behalf of ABPI Sports and Esports Study Committee, and on behalf of myself and my colleague here and coordinator of this committee, Andrea Lerner, I welcome all participants and all our great panel of colleagues. We will have time for questions at the end of our panel, but I'd like to start introducing our first guest, Dorian Slater Thomas, who practices at Frankfurt Kernet Klein and Sells, Interactive Entertainment Group and Advertising, Marketing and Public Relations Group, where he handles a wide range of transactional work for prominent agencies, brands, platforms, developers, publishers, and individual creative talent. Dorian has experience advising some of the world's best known gaming and technology companies, including developers and publishers in the interactive entertainment industry. He has negotiated and drafted development publishing agreements, licensing agreements, software agreements, and operational agreements across various digital media platforms. He regularly advises clients on a variety of development and advertising, marketing, and IP law matters, including copy and content review, network clearance, social media guidelines, copyright issues, and right of publicity issues. Dorian is admitted to practice in California and New York, and is a graduate of Tulane University Law School and University of Colorado at Boulder. It's also my pleasure to welcome Rafael Fonseca de Pinho, who's a senior attorney at Casnal Leonardo's litigation and dispute resolution team. He's a member of the Brazilian Bar Association since 2011 and a professor and coordinator of ABPI, the Brazilian Association of Industrial Property Agents program. Rafael is a litigator with more than 10 years of experience and specializes in patent, industrial design, and trademark disputes. Rafael has earned his LLB in law from the Federal University of Rio de Janeiro, postgraduate degree in marketing and entertainment law from the University of the State of Rio de Janeiro, and is a postgraduate in IP by PUC-Rio. More importantly than all, in my opinion, Rafael is a game enthusiast for more than 25 years, and will bring, for our discussion today, a perspective on Brazilian law vis-a-vis some of the issues encountered in video games and metaverse in general. So with that, I welcome everybody. Thank you for being here with us today, and I pass the baton to Dorian. Thank you, Dorian.
Fernanda, if I may only just jump in for a second.
Of course, Gabriel.
I just would like to take this opportunity to thank very much Dorian for being with us. Dorian, I'm the president of the Association of ABPI, and I will be listening to you carefully and learning with you and Rafael. But I just do not want to miss this opportunity to personally thank you for being with us. It is a great joy, a great honor to be able to learn from you. And I would also like to thank Fernanda and Andrea for their wonderful efforts as coordinators of our committee dedicated to this matter. So I wish you all an excellent encounter today. Thank you very much.
Thank you so much.
Thank you.
Yep, thank you, Gabriel. It's my pleasure to be here. And of course, yes, thank you to Fernanda and Andrea. They've been very helpful here, and obviously to my co-presenter, Rafael, as well. So with the pleasantries out of the way, shall we dig into what we're here to talk about today? Yes?
Yes.
Great. So let's start with, we're talking about generally, IP issues in the metaverse, video games, in this interactive entertainment space. So I typically like to start with just a brief sort of discussion as to what is the metaverse, right? We're hearing lots of discussions about the metaverse is here. Are you losing out on brand or other opportunities in the metaverse, or what you should be doing with your business or how you should be advising your clients in the metaverse? But a lot of us still are sort of confused as to what the metaverse is. And I'm going to say that I'm in that bucket as well, because I think importantly, we should first note that as of now, there is no singular metaverse, right? The metaverse as we know it, hold please, let me see if I can move on, there we go. As we know it is essentially, it derives from a term that was first coined in this Neil Stephenson sci-fi novel, Snow Crash, in 1992, where he first used this sort of concept of the metaverse. I think a good way to think of what the metaverse might be is the Wikipedia definition, which I know is maybe not the most legally robust source, but I use it and I like this definition. And it says, the metaverse is a concept of a future iteration of the internet made up of persistent, shared 3D virtual spaces linked to a perceived virtual universe. So I think what you can take away from that is if you're struggling to get your head around the metaverse, essentially it's the next iteration of the internet that is going to be accessible in multiple sites and essentially interoperable with multiple other internet sites or universes. There's obviously some kind of 3D or virtual reality component to it as well. We'll see what that looks like. But I think what you should think of it is sort of what we're generally calling it the next iteration of the internet, for lack of better definition. I think it's also important to talk about some of the players in the game, because although there is no singular metaverse yet that we think of like Ready Player One, the movie, there are companies and other platforms out there that are engaging in the development and the distribution of what their version of the metaverse currently is, while also working on the development and the creation of future iterations of the metaverse. I think a good example is Meta, formerly Facebook's Horizon, which is essentially a social experience that you can explore using VR or other headsets. And essentially it has this immersive social world. It's almost like Facebook is, but certainly more interactive. And it has curated programming, mini games, and you can also interact and design your own spaces or rooms within Horizon. Another platform out there is Epic and Fortnite, which started as a battle royale style game. And since then it's turned into more of like a content consumption platform where yes, you can still play battle royale, but also you can enter into Fortnite and interact in many ways, including creating your own spaces, as well as entering the Party Royale Island where you have concerts, trailers, film screenings. You might have seen, particularly over the pandemic, some of your favorite music artists performing within Fortnite, which I think just goes to show how these interactive spaces can be used in more ways than which they were originally understood to mean. There's also cosmetic features and items that you can purchase or interact with in Epic's Fortnite, and there's also still various gameplay elements. So this is just another example of what a metaverse might be, or one of the current existing versions of the metaverse. I think another popular one that people have heard of is Roblox, which is essentially the online platform where users can go and play games made by others. And there's also various Roblox worlds where you can create your own Roblox space. And I think it's also interesting to note that there have been so many brands and other entities that have engaged creators and have their own spaces within Roblox now, really sort of blending to show the commercial value of these metaverse-like spaces where you can go visit your favorite restaurant or store within a virtual environment like Roblox. I think it's also worth noting here that Roblox has the Robux, which is essentially their virtual reality coin or token here that you can use to then purchase in-world products or also engage in in-world experiences. Obviously, there's lots of talk about NFT, cryptocurrency, and other blockchain-related assets in connection with the metaverse. And I personally believe that there will be blockchain components in the future iterations of the metaverse. But I do think it's important to note that the first three examples that I just listed, Horizon, Fortnite, and Roblox, while they may be, figuring out or determining whether they would like to employ certain blockchain-related assets, currently the majority of their metaverse offerings are not blockchain or NFT based. So the takeaway there is, although I think NFT and blockchain is an important piece of the metaverse discussion, it's not the entirety of the metaverse discussion, meaning that it's not certain or guaranteed that the metaverse itself will be on the blockchain or NFT platforms that we currently know them as, or there might be some sort of hybrid where there is the ability to interact with blockchain or not. But one version of the metaverse that is related to blockchain is Sandbox, which is essentially a decentralized virtual ecosystem that, like all metaverses or metaverse-like systems, can be accessed and played from here by connecting your email, social profiles, or MetaMask wallet, which is related to crypto assets, right? Much like Roblox, Sandbox does offer the ability for users to create in-game assets and activities, but here it's based on the blockchain. And essentially the type of assets allow you to do different functions. For example, land is NFTs that represent plots of virtual land, right? So you actually own this virtual land space via the NFT. Also query what ownership looks like in NFTs, which is almost a whole nother discussion, right? Assets are tokens that represent entities like people or animals, and then sand is the native Sandbox currency, almost like Robux and Roblox, right? And then there's the Sandbox marketplace where you can purchase and publish assets. So here's a version and just another example of a metaverse, but this one with more of a blockchain crypto asset slant to it. So I think that it's important for us to think and just remember, in summary, that the metaverse is essentially this next iteration of the internet that will be accessible from many points and also interoperable. That's what we believe it will be. Currently, as the metaverse exists, we have some examples of it via Fortnite, Horizon, Roblox, Sandbox, but I think we still need to discern that the technology is still very much being built, and what I think ultimately conceive the metaverse yet as is not yet in existence, but it's still fodder for great legal discussion, which will obviously continue to be updated as the technology continues to be updated. All right, so now that we might have an understanding of what the metaverse is or what the various components of existing metaverses look like, I think we can turn to more of our legal discussion that's focusing on trademark protection, right of publicity, or image rights. And I think importantly, as Rafael and I were discussing as we were first sort of thinking through this presentation, is talking about the constitutional protections that might be available when we're having these types of discussions. So from a US perspective, we have the First Amendment, which I've copied here in this first paragraph, which at base is essentially one of the rights that the First Amendment grants, is one that prohibits, that protects free speech, not prohibits, protects free speech, which is going to include artistic expression. So I think that what we need to recognize here is that we have First Amendment protection for what we call artistic works, which the Supreme Court has stated many types of artistic expression, such as books, plays, movies, and importantly for our discussion, video games have also been found to be included in the protection of the First Amendment for artistic expression, based on, subject to some tests that we'll talk about in just a little bit that are important to us. But I think at base, what we need to think about here is that the United States does value artistic expression and does protect it through the First Amendment. And importantly, it has captured video games and movies. I think what will be interesting to see is if the metaverse is a different enough media or format to change this analysis of First Amendment protection, which I think we can go through some examples and that will help us sort of figure out how that change might look. But at base, I think we'll just recognize that the First Amendment does exist in the US and does lend protection to free speech, particularly for artistic expression. I'll hand it over to Rafael to talk a little bit about the Brazil federal constitution.
Yeah, and thank you, Dorian. Thank you, Fernanda, and Andrea for the invite. And I will try to cause a little less trouble than I can to you, Dorian, but I think that my job here is to compare the Brazilian law regarding the intellectual property and also how we apply this intellectual property rights, specialized when we are talking about games. And as the United States, the Brazil federal constitution has the protection for the freedom of speech. Of course, we have that in section 5. And also we have some protection, have all the protections for the intellectual property rights like trademarks and industrial design and inventions, of course. But the thing is that the Brazilian courts, and how I understand that they apply these rights and how they have this balance between the property rights and, of course, the freedom of speech, it's interesting. And when Dorian will show you the cases and the lawsuits that we have to discuss, but the interesting is how the Brazilian courts would do in the same situation that the US courts had analyzed it. I think that important to notice at these times that we have this kind of protection, but I think that the courts, especially in Brazil, are not yet prepared to apply the freedom of speech as the US courts have in the past. And another thing that I would like to address here is that we have to think about the video game industry not like a children industry anymore, like in the 80s or when it was developing. We have recent data that shows that 62% of the Brazilians play video games, at least because of this important device here, that is the smartphone. And if the US courts are already more prepared to deal with it because they have the developers and they have the publishers of the most valuable trademarks and companies that produce video games, but Brazil is now living a different perspective because we have a growing number of developers here in Brazil. And if we're not prepared to deal with this freedom of speech and how we can apply this kind of intellectual property rights in a different segment, that is the game industry, I assure you that we'll have some problems because the IP rights cannot be applied directly or restrict the right of this kind of industry to grow. And if I can tell to you, Dorian, if we had a World Cup of Candy Crush Saga, for example, my grandma will be part of it, and I think that he has the chances to win. So this is just to show you that an older lady from 82 years old is playing video games and is interacting with video games every day. Before she sleeps, she stays there and put on his Candy Crush Saga on his app, in iOS and plays a lot. So I think that especially when we are considering how we can apply the IP rights, we have to think about how this industry has its importance here in Brazil and the US. The game industry is growing and is now bigger than the film industry, for example. And also, but in my opinion, the Brazilian courts may not address the problem directly right now. And I think that we have different conceptions of freedom of speech that Dorian will talk about, because the freedom of speech for the Brazilian Constitution is something like you have the right to publish a work of art, for example, a book, a film, or for example, a video game. We cannot prohibit for the companies here in Brazil to do that. But we not have the sophistication yet to address this kind of freedom of speech as a test in order to oppose trademarks and intellectual property rights. And I think that's the very brilliant decisions that we have in the US court, because I think that the systematic of a case law is better for the system of IP rights if we're thinking about the civil law here in Brazil. But sorry, Dorian, I think that you can go.
No apologies. I think those are all very important points, and I'm happy to hit those home. That look, I agree, and I've had similar experiences where thinking that video games were for younger people or were not a lucrative market, but that certainly just is not true. It is one of the most lucrative forms of entertainment currently. It is one of the fastest growing forms of entertainment currently. And your grandmother is not alone. Actually, mobile users in particular, the largest and fastest growing audience is women who are over the ages of 25. So we're talking about new audiences getting into these markets that have disposable income, and it could be very lucrative to not only developers and publishers, but also to brands. So there's lots that can be said with this.
Now, I was just going to add to Rafael's point that I actually read an article today on Forbes Brazil, that Brazil is the number 2 market for NFTs so far, ahead even of the US and China. So that just tells you how plugged with this consumption in immersive experiences Brazilians are into. And to Rafael's point, maybe your grandmother's one of the next generations to buy NFTs on video games. But go on. I just wanted to add that data.
Very interesting. Very interesting. All right. So let's talk a little bit about some of other points here, right? So we laid some of the constitutional foundation, and now we're talking about certain rights that might come into play in video games, the metaverse, et cetera, and how those rights might interact with these First Amendment protections. So I'm starting a little bit of a throwback here, but I think it's important for us to know from the US perspective is that we have this Rogers test that we ultimately use in analysis with the First Amendment and trademark protection. Essentially, this was a case that was brought by Ginger Rogers, who is a famous actor or actress, excuse me, against the producer of a movie that was titled Ginger and Fred, and loosely based on this bittersweet reunion of 2 retired dancers. And Ginger Rogers brought suit against the producer here, essentially claiming right of publicity violation, as well as violation of the Lanham Act, which is our trademark protection law, federally based, that allows for a cause of action for false endorsement, which is typically brought with right of publicity as well. And essentially what she was trying to claim here is that the use of her name Ginger was meant to essentially riff off of her name in order to sell or have consumers be interested in this particular video game, or at this point in time, movie, right? So the court here recognized that we have this protection of the First Amendment, right? That we just talked about in the US that protects artistic works. But then we also have trademarks and copyrights. So we also want to make sure that the creators of works are protected via copyright, or that the owners of particular trademarks can also seek trademark protection. So at times there seems to be a little bit of a tension between this protection of free speech and artistic works, and then also wanting to foster protection of copyrights and trademarks. So in particular here, this court established the Rogers test, which is a 2-pronged test. to help determine whether or not the use of a trademark is protected by the First Amendment, or if it's not protected by the First Amendment and then therefore subject to a possible trademark infringement claim. So the first thing that we look at is whether or not the trademark is artistically relevant to the defendant's work. And then the second thing we look at is whether or not the use of the trademark is misleading as to the source of goods. In the US, trademark law is meant to protect the consumer, right? What we're really interested is making sure that the consumers aren't confused as to the source of a particular brand or product. So ultimately, that's what the second prong is really getting at, is at the end of the day, is the use in a creative work going to confuse consumers as to the source of that creative work or as the source of the use of that trademark? I think that's ultimately the focus that we will talk about today. Yes, there is this first prong, that is whether or not the trademark is artistically relevant to the work. And we'll get into some examples here, but just as a foundation, I wanted to note that courts have generally found that this first prong is a pretty low threshold. It just has to have some kind of artistic relevance. Recall, we're dealing with judges here, right? And, bless them, great people, but they are not, art critics or educated in the arts. They may be, on their own personal time, but that's not their professional focus. And the courts have really tried to step out of the bounds of not being the arbiters of what is considered art and what is not considered art. So really, even though this is a two-pronged test, the first prong is a fairly low threshold, so long as there's some kind of artistic relevance or even just relevance between the use of the trademark and the work itself. Usually courts will find that this first prong has been satisfied. So ultimately, the real test is looking at whether or not the use of the trademark is going to confuse consumers as to the source of the goods. So let's look at some examples, particularly in video games, and I think that will help us kind of figure out and better understand trademark law as it is compared to the first, or how its tension with the First Amendment protection here in the US. So this is an interesting case here. This is this ESS Entertainment versus Rockstar Videos, and this is back in 2008. And this is a case that was brought by this right-hand image, at least my right-hand side. I think it is all for you as well. It's this blue image here, and it's The Playpen, Totally Nude is the name, and it's a strip club that was in Los Angeles. And on the left-hand side is the Pigpen, which is a strip club that was included in Rockstar's Grand Theft Auto San Andreas. And the Playpen from the US, the real version here in Los Angeles, brought suit claiming trademark infringement, false endorsement against Rockstar for their use of Playpen here in Rockstar, in Grand Theft Auto. Essentially, they were claiming, that this was the use of their trademark and that consumers might be confused as to the depiction, of Pigpen here. However, the court here held that under the First Amendment, the game's depiction of Pigpen satisfied the first factor of the Rogers test because the portrayal was a satire of the seedy underbelly of Los Angeles and therefore had sufficient artistic relevance. Here, the court actually went and tried to support its finding of artistic relevance, saying that, Grand Theft Auto has these various components of this, sort of gangster-esque kind of approach. And here having this sort of seedy strip club lent sort of relevance to the game itself. I think that this is, and I would agree that there is artistic relevance here with the court, but the court found that just the fact that the game's theme sort of blended to these seedy establishments, that there was artistic relevance. And further, and more importantly here, the court found that there was no consumer confusion that Playpen, the real strip club, had endorsed or supported the production of the game. Interesting finding, right? I could see how people might argue otherwise, that if the trademarks were close enough, that consumers might think that, Playpen was trying to somehow benefit off of its inclusion into the game or wanted to actually advertise or somehow reference itself within the game. I think conversely, what I would argue, if that was actually the case, I think they would want to be identified as Playpen and really drive it home to consumers that they were involved, that they were actually a partnership here. But I think that what we take away from this particular use is that even though there was a strip club and that the names were fairly close, the court found that there was artistic relevance because the strip club lent to the theme of the game and that there was enough difference here or distinguisher between the actual strip club in reality and the strip club as depicted in the game that consumers wouldn't be confused. They wouldn't think that this pig pen in Grand Theft Auto was the same product as Playpen in Los Angeles. All right, let's go to another example. Please, here we go. Here's another interesting one. This is Dillinger versus Electronic Arts. Here you'll see this modern Dillinger gun on the left-hand side, which was a gun that was available in one of EA's games. And then on the right-hand side, you'll see this John Dillinger, who's a notorious gangster who favored these Tommy guns that arguably look similar to the modern Dillinger. And here, Dillinger brought suit against Electronic Arts, saying that they had filed several trademark registrations for John Dillinger, the actual name of the gangster, and that they sued EA for use of Dillinger as a weapon and name of a weapon in EA's Godfather games. And here, after review, the court held again that the use of Dillinger was protected under the Rogers test because it had some artistic relevance to the game. The game was Godfather. That was a game based on gangsters, and John Dillinger was a notorious gangster. So the court believed that there was enough artistic relevance between the use of the Dillinger name and the artistic focus of the game, the Godfather games. The court also found that it did not explicitly, mislead the public as to the source of the content of the work, essentially saying that the way that the gun was presented here, this Dillinger, the modern Dillinger, that there wasn't enough to indicate that John Dillinger had either endorsed the gun or was somehow also selling or the source of this particular modern Dillinger within the game itself. So here, yet again, I think the court is finding a fairly thin artistic relevance between the existing trademark, John Dillinger's name, and then the use of the trademark in a game about Godfather, or the Godfather game about gangsters. And then also basically without more, apart from just using the name, the court didn't see how consumers would think that just using somebody's name, in this instance, referring to a gun, would be enough to confuse consumers to thinking that the modern Dillinger was somehow a product or derived from the source of John Dillinger himself. This to me, and I'd be interested to hear other people's thoughts, is a little bit different than the first case. The first case we just talked about, the Playpen versus the Pigpen, there was different names, albeit close names, but they were different names. The signage and the coloring was a little bit different, right? But here, arguably, it uses almost explicitly the trademark itself, right? Like it's the Dillinger name that's used in the gun, and it's using a gun that John Dillinger frequently used. So to me, I could see the argument that there could possibly be more confusion here as to the source because it is directly using explicitly a trademark in a manner that this person had used their items in the real world, I guess. But I think it goes to show that the court is really looking for something more to confuse consumers apart from just using, the name itself. So that's something to consider if you're looking at this from the US perspective.
Dorian, may I don't know, provoke Rafael here? What's your thought on it? Because I'm with you, Dorian, in the sense that this looks slightly different from the first case. But my question to you both is, wouldn't we have an argument here that different than from comparing the first case where you could say, look, it's inspired in the original one, but it's not exactly referring to it. There's a longer way to get to the source. But here is a real direct reference to it, direct use of the trademark. And my question is, don't we have some sort of goodwill that gets along with this use that is attached to the video game? That doesn't it add value to the use when you're using my trademark? Don't I bring along with my name something more subjective than just the trademark itself? Again, on the first case, I think they diverted it enough that you can make a point. Yeah, there's a reference. Yeah, sure, there's a goodwill, but there's a longer stretch to get to you. While here is more of a direct connection. So I don't know what you think of that. I mean, this case, I would be a lot more, at least under Brazilian law, thinking that we would have a stronger case if we were Dillinger.
Yeah, I think that I will try to make my way here. Dorian. And I think that the Brazilian perspective, Fernanda, I think that we have a problem and a more objective criteria to discuss about the use of trademarks in video games or any other artistic work, for example. I think that in Brazil, the use of the trademark can be used, for example, in a literary work or book, for example, but without commercial connotation. And that's the problem that we have here in Brazil, because this is an objective criteria to use the trademark without infringing the trademark. But that's the point that I think that the video games industry is different from other kind of industry. And why do I think that the US court was correct to deal with this problem in that way? Because most part of the video games trying to deal with simulating reality. When we're thinking about the game industry, like in the 80s or in the 90s, it's just a pixel on your screen that goes side and goes up and down. And we do not have any kind of insertion in that work, for example, like scripts and characters and a more complex work of art. And I think that video games industry developed a lot from the past years, especially in the 2000s, for example. But the thing is that if we keep applying IP rights like trademarks in a very restricted way of use, we can somehow block the innovation of this industry, because we are thinking about an industry that's trying to simulate a reality that can cause you an immersion, for example, in that game. And I agree with you that in the first case, there's more a satirical way, like can be understood like a parody, for example. But in the second case, I think that the use is not able to confuse the consumers or even to think about the goodwill, because I understand that the video game industry has a different perspective for use and simulating reality, but I think that in Brazil we'll have some problems because of this commercial use. Every kind of trademark that's used with the commercial use, and in video games that's not different because the companies and the developers are selling the game after all. But I think that we have to rethink the way that we have this kind of restrictions of IP rights. Otherwise, we do not have the development in this kind of situation. Dorian, for example, and you may answer this, but in tests, in book, for example, we can have a character that's drinking Coca-Cola, and that's okay. And I name the brand, the trademark, Coca-Cola. But when I put that on a video game, I think that we have different understandings. And that's why I think that we have to think video games as an expression. And I think that, in my opinion, Dorian, the court in the US handled the problem very well.
Sure, good point. I think first, we're dealing here, well, many things. I think many things. Let's start with, my brain moves faster than my mouth. So first and foremost, we're talking here about a video game that's what we're talking, protected by artistic expression. So an artistic work. And it sounds like in Brazil, right, like a book solidly falls within an artistic work. So we feel comfortable having the reference to Coke there. It may get different with different types of media, right? Like a video game itself, and it feels a little bit more commercial, selling the video game that has the use of Coke in it. And I agree. I also think that video games feel a little bit more commercial in some ways. And I think even more so, we're looking at this with hindsight, right? Like when these cases were decided, this was 2011, the Dillinger case. I'm trying to go back, I think it was. Yeah, 2011. This was really before we had a ton of like loot boxes and virtual currencies and things that were actually for sale within these video games. It was just at the start of this, really. So now that we're seeing more of this commercialization of these artistic expressions, I do think that there's going to be some change in analysis, whether it's no longer using the artistic works protection and looking more at it from commercial speech, or if we're somehow going to change this test or look at the tests differently now that these types of media are having more commercial components to them. So I think it's going to be interesting to see, and just noting that the US does, if it is commercial speech, it may not be subject to the same protections as artistic expression, right? And so if you're blatantly using another's trademark in a commercial manner and benefiting therefrom, like it may not have the same protection that we're talking about here. But I think the court doesn't find that to the same degree when we're talking about a video game in a whole. I think this would be a very different case if it was a gun manufacturer that was selling like real world guns called the Dillinger. But we're getting closer to that, right? Like with the metaverse and NFT,
Metaverse, exactly.
we're
That was
getting much
my point.
closer.
Yep.
So I do think that these things will be changing. But these are the foundational tools that we have to look at these analyses. And so here the court found fine. It would be interesting to see, you know, in today's court, 12 years later, 11 years later, if they still felt that this was, particularly say you could buy the John Dillinger gun, right? Like, could you buy the John Dillinger gun in virtual reality and that's how you're using it? Maybe that's a little bit different. Does the analysis also change if, does John Dillinger's family sell digital guns that you can buy? And so here, if you buy the EA gun using the Dillinger name, are you then confusing people to source? That could be a little bit more confusion. So I think we have to look at these cases and know that the technology is just changing so quickly that it's going to be likely, I think, that some of these cases will be changing, or the way that we use them will be changing. To your point with Brazil, though. Oh, go ahead, Fernanda.
No, I was going to say that's a great point, because obviously these cases are the foundations, what we have today, and even in Brazil, what we have as case law as a basis. But as you said, as the technology changes, that changes a lot of facts from that base those decisions. So we have to learn and know how metaverse and NFT and blockchain works to be able to, you know, make maybe different arguments than it was proposed back in 2011 from this case. It's a great point.
I think that's right. But I do think, to your point too, Rafael, that it's to the extent that Brazil is interested in continuing to have like a robust game development economy, it's going to be important that there are protections for artistic expression to allow for that. Conversely, though, and without sounding like a hypocrite, we also need to make sure that we're protecting brands sufficiently as well, because they're the ones who bring the money to the game development. So it's really this tightrope that you have to walk. You have to allow for the artistic creation, but then you also have to give brands the confidence that their IP will be protected, so that they feel comfortable sponsoring these products and sponsoring these developers so that the games can continue to exist. And fortunately, because of that tension, we get work. So it works out for the lawyers in the long run. Let's see, here's another example that we're talking about, also from 2011. This is a mil-spec, which is essentially this angry monkey patch that they have here on the left, and then an Activision Call of Duty. You can kind of see in the bottom right, there's also this like angry monkey feature here. And here again, similarly, mil-spec sued Activision for trademark infringement for including the patch of Call of Duty that had this angry monkey. And yet again, the court used the Rogers test. And here the court found that there was artistic relevance, and because there was this military environment that Call of Duty had created, and therefore these military patches were artistically relevant, and yet again, not confused to source. I think this is really just a compound example from the previous one. If patches were for sale, for example, or otherwise monetized as they can be today, I'm wondering if there would be more of a confusion to source and there might be a different outcome here. I think both of these cases really highlight, though, that first prong with regard to artistic relevance is pretty low, right? Like, this is, all right, a military patch in a military game, fine, we're there. So I think that's interesting. Let's see here. This is also a similar one, just a year later, Electronic Arts and Textron. And this here we have, you know, the depiction of a helicopter in Battlefield, EA's game, and then an actual one of these AH-1Z helicopters. You can see they look pretty similar. This is sort of an interesting case, though, because EA, perhaps being sued previously, filed a preventative suit trying to have the court issue a declaratory judgment that the use was not trademark infringement. And what they try to do here was asserting basically the minimal use is what they said, is this is just like one helicopter in a whole game kind of thing. And the court was saying that just this prominence piece doesn't necessarily get us out of the analysis, that we would still have to run it through the Rogers test and see if this was subject to First Amendment protection. But ultimately the case was settled before then. But I think this is a good example of showing that the First Amendment test was so useful, particularly to developers of games and platforms, that they even went so far as trying to use it as a preventative measure when they thought they might be subject to trademark infringement. Here's another military-based one, and this one I think is interesting because it's a little bit more recent, right? It's from 2020, and this one is the use of these Humvees. You can see on the left-hand side, these are actual Humvees, and then on the right-hand side, these are depictions of Humvees in the Call of Duty. And again, here we have AM General, who is a manufacturer of these Humvees, sued Activision for the inclusion of the Humvees. They also used the trademark Humvees in Call of Duty. And here Activision moved for summary judgment, claiming that its use of Humvees was protected by the First Amendment. And here the court applied the Rogers test, finding the first prong was satisfied because the use of Humvees is relevant to simulating modern warfare, and finds that it was not explicitly misleading because this manufacturer of Humvees didn't manufacture these virtual Humvees, right? Like there doesn't seem to be a confusion of source. So yet again, here's another case, I think holding fairly similarly and fairly friendly to the platforms or the developers. But again, as we've sort of been discussing, and as we will discuss further after a brief interlude from Rafael, there are some more recent cases that have been brought, particularly with metaverse or NFT related assets. And I'm interested to see how that might change this analysis.
Yeah, Dorian, and I agree with you that the most delicate case that I look at your presentation is the monkey patch, because I think in that exactly case, we do not have this artistic necessity for the work about this monkey patch. Okay, it's a video game that's about war. It's about military situations, and monkey patch is artistic relevant. I think that's the question that I would like to address to the U.S. courts in that point. But in all of the rest of the precedents that you show, I think that the difference, as I said, for the Brazilian perspective, is that the fair use is authorized, although if we not consider that this use has any commercial connotation, for example, in a trademark or, for example, a design. And I would like to ask some questions, and we can discuss that, because you answered that, because when you said it's different when we are analyzing the in-games trademark use, and when we are analyzing the day-by-day use of trademarks. I'm not comparing a product, for example. I'm not comparing when I put a Coke trademark or a brand in my game, I'm not using that to sell Coke, because anyone can buy a Coke reading a book, or for example, or playing a video game. But when I think about the digital experience and metaverse and video games that we're going to discuss later, yes, that will be a problem. I agree with you. But I think that the courts in Brazil will have this case decided not only by the test, that the Rogers test that you said, Dorian. And I think that's a little bit disappointing, because I think that's an interesting test. But they will decide if this use of trademark has or do not have any commercial use any commercial connotation for the person that's using, for the developer that's using that trademark in the video games. And I think that is to restrict the way that we think the video games industry. But some cases, I think that we have to apply, like the monkey patch case for me is different. But I think that difference from the Brazilian perspective is that although we may think that the use of trademark cannot mislead the consumers, that cannot cause consumer confusion, for example, although we have the freedom of speech to use that trademark in a context of simulation the reality, for example, that has an importance to the game. But I think that will stop the analysis in this commercial connotation of the use. And I think that it's very difficult to use a trademark, a third-party trademark in a video game without paying or licensing this trademark, without having any problems in Brazil. And that's the only point that I would like to address about the differences. But monkey patch, I really disagree with the courts in the United States. I don't have any point, but I disagree.
No, I appreciate that. And look, it's also, I mean, these cases are useful to have. And I think, I think particularly when representing developers and platforms, that the precedent that we have so far provides some relief, so long as we're falling within this Rogers test that there's artistic relevance and there's no confusion to source. That being said, when I'm advising, right, on creation of video games, and we have, prominent and consistent uses of certain third-party intellectual property rights, trademarks, otherwise, we certainly have the discussion as to whether or not we should just preemptively clear those rights, right? Should we seek a license? Do we even want to be sued? That's even though ultimately summary judgment might be in our favor or motion to dismiss might be in our favor, we would still have to expend time, energy, money, resources to defend a suit, right? So I think that it's important to know that although this test and the protection of the First Amendment is out there, that it's certainly part of the analysis and going through copy review of a game or talking to these developers, like, is it in our best interest to proceed in licensing some of these uses? And I think that also depends upon the commercial nature of these uses, right? Particularly with these digital assets, I'll tell you for sure that we're licensing, if we have skins or if we're selling digital, virtual things within games that feels very commercial as opposed to an artistic representation, that the conversation is very different, right? We're focusing on getting licenses for those. So I think it really depends upon the particular use. So while these tools are available to us, this Rogers test and the First Amendment protection, when I'm advising these developers, it's not, oh, go ahead, life is good, do whatever you want. It really is thinking through, do we think we have artistic relevance here? Is this an expressive work? Is it subject to First Amendment protection? Are we confusing consumers? And going through the test and then really figuring out, in some instances, 100%, there's high risk, we've got to license these uses. So that goes to sort of the balance between the First Amendment protection and then offering protection for IP rights, particularly for brand holders and other third-party rights holders, to ultimately get to where you are.
Wonderful, couldn't agree more.
Oh, sorry, Rafael, we have these in-game mods. It's a good time to talk about
Okay,
these.
it's just a brief introduction about in-game modifications, and I think that's similar to the one that we're going to discuss about the metaverse and how the gamers can change the in-game features and how they do that. In more than in-game modifications, somehow the gamers can modify the source of the code, that's the software, in order to apply some features that were not allowed in the original game, for example. Sometimes the companies that are developers authorizes this modification by a free license, for example, to do that. Counter-Strike, for example, is one of the major games in the world right now, and it was born, for example, from a Half-Life game that's also by Valve, and they had the authorizations by the gamers to change some features in the game, and they created another game. Of course, this game belongs to Valve. Valve was a smart one. Okay, do that for me, and I will have all the property in this game. But the thing is, when the developers do not authorize these modifications, and we have a lot in the internet. For example, I put that here in the Grand Theft Auto. There are a lot of modifications, in-game modifications and features, and they put, for example, the Fusca here in Brazil, Dorian, and the Beetle in the United States. There's a design of a very famous car here in Brazil, and they put that on the video games, for example, and Pizza Hut, for example. And we put that on the video games in order to simulate to create a more immersive gameplay. But the thing is, when the companies authorizes these modifications, okay, the responsibility is from the companies that authorizes, for example, a third party or a gamer. When changing and modify the source code of the game, they will probably have a problem because they are infringing trademarks. They're putting their trademarks in the game without authorization. But when the gamers do that without the authorization of the developers, that's a question that I would like to address to you and Fernanda to discuss here, because I think that's very difficult for the developers to control that. But the in-game modifications by the game users, they happens a lot. And if you look in the internet, there's a lot of in-game modification, and a lot of them uses trademarks and intellectual property rights from third parties. And I think that if you do not have a control of that, you may be responsibilized. For example, you may be responsible for this use created by the gamers. Just that point that I want to address.
Sure, definitely an interesting point, and one that I think is very valid. And it touches on a huge topic that I've been speaking on and working with clients a lot lately is content moderation. How are we moderating content and users' behaviors within video games and ultimately the metaverse, right? If we have this huge interactive virtual world where we're all living and doing things and buying things and interacting with one another, like, do we have the metaverse police? Like, what are we doing to help make sure that people aren't engaging in infringing actions? And so I think that particularly there's lots of brand guidelines that have been put out there. If you're licensing materials from brands, to have these brands allowed to be created like third-party assets or whatever within the games, there's lots of usage restrictions or how those might look. So I think that there's a lot of burden on the platforms in some ways to try to make sure that the use of their trademark third parties is acceptable to those third parties. But then I also think that there's lots of onus put on the brands themselves to have to police users' use of those particular brands. We have various intellectual property right protections and safe harbors. This is more copyright focused, right? When we have the DMCA, the Digital Millennium Copyright Act, which allows for this safe harbor where essentially publishers are just, publishers of materials and can't be held liable for the user-generated content that's uploaded. We're even seeing that kind of being attacked in the US a little bit, particularly when we have these platforms and these publishers that are making, huge amounts of money off of these games and then saying, oh, we're not doing anything, we're just allowing for this space. So it's hard to tell how that might ultimately look, particularly also, let's say if these platforms or games for the metaverse are engaging or even incentivizing users to create these worlds or create these types of content, can they still be saying that we're not really involved here, we're just a publisher, we're not a speaker of the content? So I think that that's also going to be an analysis that we have to change. Really, it's the interactive and interoperable nature that we're now dealing with, that it used to be just sort of like a movie, right? Like, here's 2D, you have no control over it. Maybe you can fast forward and rewind it, but you're not actually interacting or able to change the content itself. But now that we're living in these interactive spaces where you can kind of choose your own adventure and use these tools to modify these assets, I do think that there is a different paradigm that we're dealing with. And it's ultimately going to come down. I mean, it's going to be a test or an analysis to see who is liable for that. Is it the particular user? Is it the platform? And even more so, how can we police these uses? And it's incredibly important, particularly if we're expecting brands to be involved. I'm looking here at your example, and we have Pizza Hut here, which again, sort of like the timing component. I feel like perhaps if this were in the US and Pizza Hut was relevant to the particular game, maybe this would be an artistic use that didn't confuse consumers. But now today we have Chipotle in Roblox, right? And Chipotle has paid a ton of money to be in Roblox, be one of the first restaurants that's available. They have, you can go in and make your own digital burrito and buy certain assets that will then ultimately allow you to have, physical burritos in the real world. So I think that the test very much changes as to whether or not, these are just artistic choices, or if they can potentially have effects on the consumer and confusing consumers as to the source of these goods. So modification of trademarks and assets, I think, is huge, and it's going to continue to be something that we have to look at.
Yeah, this is just to reproduce and to illustrate what you're telling us right now, because there are some major trademarks that are putting their trademarks in their games and paying a lot for that. For example, the Fortnite and has a lot of license agreements with trademarks in order to put these trademarks in the game, and the Air Jordans in this case, and in Burberry, for example, in Honor of the Kings, that's a app game. for iOS. And I think that only illustrates what we were talking about, the possibilities and how this can harm the industry that are putting their trademarks in the video games, and they are making a lot of money to do that.
Totally agree. Totally agree. I think that's a good transition to some of the stuff that's been happening in the US, particularly in this metaversal digital world. This is a case that popped up recently. The image on the left is one from StockX that was, it's kind of unique facts here. They were selling NFTs, and here's a representation of one of the NFTs of these sneakers that allegedly corresponded to vintage and rare Nike sneakers that StockX had, like physical sneakers, right? So if you bought the NFT, not only would you have this digital image or be able to use this digital image, right, in your NFT portfolio, presumably you would also then have purchased the real world vintage sneakers, right? So obviously when this happened and they saw that their trademark, particularly the Nike swoosh was being used, Nike started sniffing around and ultimately brought suit against StockX, here claiming trademark infringement, Nike swoop, and also the shoe itself, right? And I think there's an important thing, a couple of things to note here. One, there was sale of a digital asset here, right? Like the NFT itself with this shoe is something that somebody could hold in their digital wallet, and something that they would, or their NFT collection, and something that is of value to them, whether or not they trade it, or even if it's just their own personal value, right? As well as the physical shoe itself. So I think that there was talk here, obviously, about whether or not StockX has the right to advertise that it's selling these physical shoes. And we have the first sale doctrine and also other protections in the US for allowing fair use to allow to sell a particular good that you can advertise, and you can say, this is the Nike shoe that I'm selling. But StockX was doing more than just advertising, right? Like they were selling that advertisement as well, that advertisement being the NFT. So I think that that's kind of a unique twist that these digital assets allow, that just because you're using an NFT to possibly represent the sale of a digital or physical good, the NFT itself is essentially a consumable good, right? Well, a non-fungible consumable good, but something that you could still purchase and hold. I think what's also important here is that Nike has been getting into the digital space as well, right? So it's not just that StockX was creating these NFTs that had the Nike shoes and they were the only digital Nike assets. As you sort of alluded to in your previous slide, Rafael, Nike has entered the chat, right? Like they're already involved and heavily involved in various metaspace capacities. So I think that there is a likelihood for confusion, in that there could very likely be that Nike has an NFT of a shoe that's similar to the shoe here. And so they are in potentially direct competition in that regard. I think another interesting fact that kind of came out here that doesn't necessarily have anything to do with sort of the digital nature of this, but after doing some investigation, allegedly, a lot of the shoes that StockX is selling were fake. So not only were they sort of creating this like digital trademark nightmare, at the end of the day, they were kind of going back to an old trademark nightmare, which is like selling knockoff goods, right? So that even kind of creeps into trademark a little bit, is that how are we dealing with these kind of knockoff good cases? But I think it's an important point here to show that this is I wouldn't say because of StockX, but contemporaneously, we have Nike that is filing in the US USPTO, so the Patent and Trademark Office is filing to update these trademark registrations for digital assets, right? So it's clearly signaling to other people and to other brands that it's getting into digital asset space, and even trying to protect their goods in those spaces. Talking to some brands, they feel like their current trademarks protect or are broad enough to be read to include digital assets. And I'm not really going to opine on that because I think it can go either way. But I would note here that Nike, which is a significant brand, is taking the step, and other brands have also started taking the step as well to start registering their trademarks to cover digital assets. And it all goes to the fact that these brands are engaging in certain versions of the metaverse to quite significant degrees. Not only are they in games like Fortnite and etc., but they've also, big one is Nike Land in Roblox. And here are some images of Nike Land in Roblox where you can go in and purchase Nike assets for your avatar here. But I would note that my stats are a little outdated. It's June, but as of March of this year, so 3 months ago, Nike Land had already 70 million visitors within Roblox. So 70 million people had gone in and visited the Nike virtual Roblox. So it's clear, I think consumers are recognizing that there could be official authorized Nike digital assets, which would go to trademark, in that trademark is meant to protect consumers, right? So if consumers see other digital Nike assets out there, they could be confused as to whether or not those are sourced from Nike or for some other source. So I think this really brings home that now in the metaverse, there's more of a direct route for consumer confusion and ultimately trademark infringement, as opposed to before having all of these massive sort of in digital world experiences in stores.
I was just going to mention that Nike, for example, but many others have also extended these US filings to other jurisdictions, such as Brazil. So that shows, in my view, that not speaking for Nike, of course, but as a matter of strategy, if you are selling products in metaverse, if you're selling NFTs, you might as well, not get caught by surprise of not having downloadable in your description of goods and take the risk of strengthening the argument of, First Amendment or art, the whole Meta Birkin kind of argument that is not a sale, but is that rather an expression of art, because that's what that, the Stocks Act also has in terms of novelty. So I agree with you. I can't cross for sure the strategy on whether to file, whether it's necessary to file for downloadable goods, but it's on a case by brand case basis. And I think we're too new in the territory to be certain of one way or another, but there are ups and downs of both strategies.
Completely agree. And you mentioned, let's do it. Let's talk about Meta Birkin. So this is Meta Birkin. This artist, I think his first name is Mason Rothschild, was creating these NFTs that were represented by these digital Birkins, these virtual Birkins that you can see images of here, that are kind of cool looking. And was then selling these NFTs, particularly during the craze of NFT art that happened recently. And it's still somewhat happening, but for a while there, it was certainly one of the hottest investment markets, or at least consumable markets around. And Hermes brought suit against Rothschild here, claiming of many things. One is Lanham Act, false endorsement, and use of trademark. Rothschild, in responding here, and much like the Rogers-Grimaldi test, right? We're looking here to see if there's artistic relevance and confusion as to source. And so I think this is a great example to sort of walk through if we're looking at these digital NFT Birkins through the Rogers test and seeing if that is somehow changed now that we're in this new crypto metaverse era. The art, I guess, here is some sort of critique or comment upon, the status of the Birkin and how it might, the creation of wealth or the type of person who might have a Birkin or what the Birkin actually means. So I think that there could be some kind of argument that could be made that there's artistic relevance here to the expression of these Birkins, right? Like he could be commenting upon certain consumerist or even, luxury goods, et cetera. And as we know, and as I talked about earlier, like you could pretty much cobble together any kind of argument to make that there's artistic expression or artistic relevance, right? Because the courts, at least as of now, have had such a low threshold for artistic relevance. So I'm reticent to say that there's not artistic relevance here. I think where the really interesting discussion comes from is if there's confusion as to the source of the goods. So as of now, you can not purchase like a digital official Hermes Birkin in, say, like Roblox. But what if you could? What if you could purchase a digital Birkin? What if Hermes was making digital Birkins officially as NFTs? From that standpoint, I think that there is a much more compelling argument that consumers could be confused as to whether or not Rothschild's NFT Meta Birkins were official Hermes Birkins, or if the other official Hermes NFT or digital assets were the real product. So to me, once we have these, physical or digital goods, really comes into play and helps to determine whether or not there is some kind of consumer confusion. I would note here that a lot of luxury brands have since started either registering their trademarks or even opening up some kinds of digital asset storefronts or offering digital assets. I can't say they're only doing it because they want to better show that there's a consumer confusion in a trademark infringement place, but I do think that it is something to think about in the current state, that if you are a luxury brand or any type of brand who may be, easily replicated or used by these artists for NFT, other digital assets, it might be something to think about how you intend or envision your brand engaging in these digital environments in the future, and whether or not, now is the time to start getting into the space and possibly taking advantage of some of these arguments that there could be consumer confusion. But I'm curious, Rafael, in Brazil, if there was something like this, would this be subject to any First Amendment protections or artistic relevance? Like how do you think this would play out?
No, I think that in this case, Dorian, it will be a lot simpler. It's not being so difficult. I think that you're using a trademark in a digital environment is still a use of trademark. And of course, if you are not authorized to proceed this way, I think that the Brazilian courts will have this easier path in order to decide for the trademark infringement. I think that will not have this kind of detailed analysis about if the product is protected in the digital environment or not. After all, like Fernanda said before, you're using the goodwill of the trademark and you're trying to assess this goodwill. So I think we do not have this kind of substantial discussion, but for me, it's a trademark infringement.
Got it. And look, it might also change in the US pretty quickly because, say, for example, NFTs are classified as securities in the near future, and thus they're investment tools and maybe not art or subject to, First Amendment protection as being artistic works. I think that could immediately change the analysis here, right? Like if we're dealing solely with commercial speech or with investment tools, obviously this is a little bit of a hybrid because we have, and this is not a blockchain or NFT discussion, but we have the difference between the NFT itself and then the piece of art that may be represented with the NFT. So it can still be a little bit more nuanced. So maybe it would still apply in some ways to the extent that we're talking solely about the artistic expression piece. But I do think that the commercialization that's involved here with these NFTs, like this Hermes, the Meta Birkin, is certainly a lot different, at least in my mind, than having, the pig pin and the playpen in Grand Theft Auto.
I totally agree with you.
I'm just checking in on time because I talk a lot without looking at the clock. And we've only covered trademarks, and we still have some right of publicity stuff, and we also have Q&A. So sort of informally checking in here, I'm happy to continue our discussion, particularly with false endorsement in trademark, sort of from an ROP, right of publicity perspective. I'm also, if you all think this is a good time to stop and ask for questions, I'm happy to do that as well.
I think we have one question actually about patent, but as to timing the rest of the presentation, I think you have already laid the foundation big time from the First Amendment point of view, and then trademark sort of fair use in that space. So I think we have about 15 minutes or so to cover the rest of the presentation. I think you can probably scan a little bit just on those, so we don't miss the richness of the discussion, but I want to make sure that we address the question that we have here on chat.
Yeah, sure.
Do you want to read the question for us?
I think that you're muted, Andrea.
Oh, you're mute, yeah.
Sorry. The question is, what about the patents right in the games? The game could use a patented gun or any other technology? It's from Danilo Campronio. I don't know if he's still here, but.
Sure. So thank you for the question. So I found this, and I think this, actually call me, Danilo, sometime, because I'm interested to talk more about it. In my conversations, particularly with lawyers in Latin and South America, patent seems to come up a lot. But I'll be honest with you, in the US, patent doesn't come up a ton. And the reason why patent isn't coming up a lot, because we're dealing with these video games and software products that are in code. So really what we're talking about here is the expression or the digital representation of a patented good, right? Not the actual creation of the patented good. So when we're doing that in the software context, we're doing it via code, which is protected by copyright protection. So really the expression of a particular patented good is either, I mean, if you're looking to bring some kind of claim, you're not really bringing a patent claim because you're not necessarily making a competing physical good. You're either worried about the copyright representation of that particular good or the trade dress trademark representation of that particular good. So really the expression, due to the expression of these works, the claims are more rooted in soft IP. So that's would be copyright or trademark and not necessarily hard IP like the patent rights. Now, this might be a different case if, say, you have your Oculus headset, right? And that might be a patented physical good, and then you're creating a knockoff of that, or you're somehow using that patented, virtual reality headset component. That's where we might get some of these patent claims. But when we're talking about like the physical or the digital, expression of these particular patented items, it's more like the copyright or the trademark expression of that patented item and not the underlying patent itself.
Totally agree with you, Dorian. I think that the same explanation that you have for the US perspective is applied by the Brazilian law. We do not have here implemented the solution, the technical solution itself. We have only a visual perspective of this patent, for example, product, but it is more visual and so is more related to the trademarks, designs, and trade dress, for example, kind of IP rights, because they are dealing with our vision itself and how we see these products represented, not for the invention itself represented or the solution, technical solution implemented in the digital world. So the explanation was great and it works for me too.
Right, I like it when we agree. I mean, I also like it when we disagree, but I like it when
yeah.
we agree. Okay, cool. So let's do like a flying drive through right of publicity. And I think, to be fair, it's actually probably something we could cover pretty quickly. So we're also taking a look at the right of publicity from this false endorsement sort of trademark perspective, right? In the US, we don't have a federal law that explicitly covers like the typical right of publicity or image rights that you might think of in Brazil. We have state laws, various ones that protect the uses of a person's name, image, likeness, et cetera, et cetera, et cetera. But we also, through the Lanham Act, have this essentially like this false endorsement claim that can be used by persons as well. And so oftentimes, particularly if you have like a big celebrity or something like that, and you're getting a claim for right of publicity infringement within a game, typically there's also this false endorsement claim that comes with it that is a component of our Lanham Act, which is our trademark statute or federal trademark statute. So kind of setting the stage here, we also have this, yet again, through trademark, First Amendment protections, and particularly with the right of publicity component. And really what it comes down to is this transformative use test, which we can think of as like the Rogers test in this particular capacity when we're talking about a right of publicity sort of case. And essentially, it's just looking to see if the use of a person's name or likeness is transformed to a degree that's beyond just name and likeness. So what does that mean? I mean, really, it's very, very much legal language, but that's what we're looking for is the degree of transformation. So it's difficult to really pinpoint where that degree is. But when counseling, I mean, I think the easiest way to counsel is just the more you can transform, the better, right? The more that you can transform away from a particular name or likeness, the less likely that the more strong of a case you would have that there's a transformative use. And so that's one way to think through it. Obviously, that's difficult because that's the easy answer. So it's really getting into the weeds to see as to whether or not something is a transformative use or not. Here's an example here. This is this Kirby versus Sega America. And this is this lead singer of the group D-Light, which I mean, I am a pop fan, but I have to say I'm not super familiar with them. But you know, no disrespect to the D-Light fans out there. Claimed that Sega violated her rights of publicity through this Ooh La La character, and you can see D-Light versus Ooh La La. And here the court applied the transformative use test and found that the Ooh La La character was altered enough and had enough creative elements that entitled Sega to First Amendment protection here. And sure, I see some differences, like there's ponytails, there's purple versus red hair, there's, I don't know, kind of orange and red, different things. I mean, to me, is there similarity? Sure, but is there like a direct implication? I would sort of tend to agree. This also might just be the result of technology, right? Like this was back in 2006, so clearly this was used before. So there wasn't the tech to have like the super, you know, defined kind of really mirrored aspects that we have today. So that might have actually benefited Sega in a lot of ways, and that it was like physically or technically impossible for them to completely replicate this particular singer. But ultimately, I would tend to agree that if I saw this Ooh La La, I wouldn't, the first thing in my mind would not be this particular singer from D-Light. So that's one example. Here's one that differs a little bit. This is one that no doubt Gwen Stefani is seen here, brought for the use of No Doubt in Band Hero, which is sort of like a Guitar Hero, right? And here Activision argued that the use was transformative because it put the band in unusual circumstances, such as performing in space. I appreciate the argument, but it still is essentially using No Doubt as a band to perform music, which is what they do, right? And it also, to me, this, like, if I saw this person here, this digital representation in conjunction with these guitars, and being perhaps a No Doubt and Gwen Stefani fan, I will admit, I would think of Gwen Stefani. So to me, this conjures her personality, this conjures her image. And here the court agreed and found that it was not transformative, that still the avatars were performing rock songs, which is the same activity that they do in real life. And even though there were some other creative elements, that there was still like exact depictions of No Doubt's members doing exactly what they do as celebrities. So I think here, this is a pretty clear-cut example. Like it's a pretty clear depiction of the person, and it's also depicting them doing what they do. So there was really a hard argument here to say that this was a transformative use. Let's see, I think we got a couple more. Here, this is Heart versus Electronic Arts, and this is a player's case. And it says here, this was a class action, which is interesting because it was for use of players' real life physical features, clothing and accessories, biographical data. So a lot of these, you know, football and sports games, which I'm sure are very popular in Brazil, soccer games, as we call up here, you know, we use lots of player information, right? Like we might use their name, their likeness, their stats, etc. Also think here, there's lots of rights to think about. I know I'm kind of going afield here, but we have like the team trademarks, colors. Also, you know, if you're getting those trademark licenses, and this opens up a whole nother can of worms, but say you're getting a trademark license from, you know, the particular league or team, or license generally to use their players in the game, do you still have to get permission from the player themselves? So really athletes present lots of risks just because there's so many rights that are tied to them. But here, what EA claimed in response was, and kind of related to Rafael's earlier point, was that users could change the appearance of these players, like, you know, different hair, different colors, different styles, etc. But essentially, what the court held was that it wasn't transformative and didn't think that the changing of the avatars was enough, particularly because they were looking at this from the long game, saying that just because a game is interactive, that it can't get you out of this like trademark analysis, because if it did, then all video games would sort of get out of this right of publicity, transformative use analysis. But they did note here that it, you know, it could be an element to look at is the type and extent of interactivity. So if you could completely change it so that it's no longer recognizable, perhaps that's a sufficiently transformative use. But just the fact that you can allow for some kind of interactive nature with these trademarks or right of publicity isn't sufficient to say that it's no longer, you know, subject, or that it is transformative. You have to show the degree of the interactivity to even have that argument as to whether or not that feature allows for the transformative finding. So at the end of the day, still athletes playing football, using very, recognizable features. So just the fact that you could change some of their features wasn't enough to find that it was transformative. I think one of our final examples is this Lindsay Lohan Take Two, which I actually think is kind of interesting. Here, Lohan's, again, another Grand Theft Auto case, going full circle, sort of ending where we started, where Lindsay Lohan sued Take Two here for Grand Theft Auto 5 for this Lacey Jonas, claiming that it was unlawful use of her likeness. The court decided the character was not a portrait of Lohan. And it says the artistic renderings are indistinct, satirical representations of the style, look, and persona of a modern, beach-going young woman that are not reasonably identifiable. So here the court found that it was transformative. I would say, like, kudos to whoever put these two images together, because to me, this is like a pretty, like, they're the same pose, the same bikini. It would be awesome if you could see her leg and there was like one of those jail monitors on it. I don't think that was in the case. But to me, this is almost a close call, like, because I don't know if this is super transformative. Now, that being said, perhaps Lindsay here in this particular photo is like engaged in a very generic image, like this beachgoer party girl. So maybe that's the way we can look at it. But I almost second guess this one in that, to me, the two images seem fairly similar, and I'm not so sure about the transformative use.
Dorian, let me ask you a question. As you said, look, if I was looking at this picture, your reaction to it, I had the opposite reaction, thinking there's no way this is her. I bought their defense. But my question to you is, when you're counseling a client and you're reviewing the product, do you ask moment by moment or shot by shot or on another basis for the creative background for the creation of something like this? Do you actually go there with clients so you can at least you're able to do your full job versus your reaction to it, my reaction to it, which we're looking at the same thing? I would never think of Lindsay Lohan, except that if I saw this picture next to it, or these are my inspirations, maybe as would trigger a risk alert here. But if I just looked at this in a context of a video game, I would never think to clear it. Maybe we would ask, is this inspiring someone specifically? But other than that, I wouldn't go further than that, just, looking very, very shallow.
Sure, good question. Yes, I mean, it comes to me a couple of ways, and it being problematic uses, right? Sometimes I'll take a look at the beta versions or storyboards or even final games or content. And to me, just because I'm a consumer of popular content, I'll see something and be like, yo, this seems very similar. Like, where did we get this? A lot of times too, what really goes into the development process is defining sources of inspiration, right? Like, if you're talking to your content developers, like where we're getting these sources of inspiration from, and really making sure that if we're using real world people or IP rights or whatever it is, that we're making sure that they are just inspiration and that we're not copying, right? So again, it goes to this transformative piece where it's like, okay, great. You think Lindsay Lohan's hot and you want her in the game. I'm totally cool with that. Let's just make sure that we're presenting her in a manner that doesn't clearly indicate that it's her. So sometimes it's actually the inspiration materials that get you in trouble too. So, you go in the US, you get a lawsuit and you go through discovery, right? Where you have to disclose all these materials. And then say you disclose the materials and it's a bunch of photos of Lindsay Lohan, then I think you got yourself a little bit of a problem there, right? So I look at it as from a whole. I do a two, it comes in many ways. One, it might come early on where they're already telling me we want, a hot girl Lindsay, and I'll be like, all right, let's get away from saying Lindsay. Let's try to find multiple images. Let's just say like hot beach girl, right? And then use that as our analysis or our source of inspiration. And from the early stages, get away from trying to anchoring ourselves with her. And so that way it might become and create more of an original image. Here, I think it's not just the image of this woman. Her name is also Lacey Jonas, which is somewhat similar. Like, it's an L name. Jonas and Lohan is like two letters different. Like, I think they were kind of towing the line here. So to me, I think, no, if I just saw this and didn't know her name and didn't see this other image, to be honest, I probably would flip by it too. But like, now having seen some of the other facts, I'm a little bit, I would be a little bit hesitant. I think the band hero game would be something that you could see immediately. And you should also already be talking about, like, are we licensing the music rights, right? Like, there's already a lot of third-party content in there that you're probably thinking about. But that's a good point. Like, just because you're licensing the music, that doesn't necessarily mean that you then have the rights to use Gwen Stefani's image as well. So it gets complicated fast.
Wonderful. Great. Please
Yeah,
go
I
on.
think that in sports simulating reality that we have, I think the image rights and of course the right of publicity is much more questionable, because the developers that work with this kind of segment of games industry, that sports that simulate reality, they have a difficult job to do, because they have to create something that emulates the reality, that simulates the reality. And so you have to be the most perfect that you can be when simulating this reality, but at the same time you're using the images of the athletes, because you need that to input the simulation and to input the reality to the discussion. So I think that for the esports games, it's very difficult to go away without licensing the image rights. And they have some big troubles here in Brazil regarding this kind of license, because as you know, Dorian, we have football as a religion here in Brazil, not the American football, because the football here is with our feet. But we have some, it's really important, and to create this reality and to create this environment of reality is very important. Nobody wants to play if you're not playing with Neymar, and you're not playing with Messi, and we are not playing with Cristiano Ronaldo. You have to play with them. Without, it's not a soccer game. You can't do that. And so I think that for this kind of industry and games, it's very difficult. And I read some news about this kind of problems that other fictional games are facing right now, because right now we have some games that uses actors in order to be the characters of the in-game character, and they also have to license the image rights of these actors, and in order to put that on the game. And it's very difficult, because you have to do that for a film, for example, for a marketing purpose, but you also have to do that to the video games. And as you said, it's very complex, it's very different. And I think the best way, I agree with you, Dorian, in the US or in Brazil, you have to be very careful, and if it's possible, license the image and license the trademarks, because you may face a hard time if you not do that.
I agree. It can be expensive to ask for forgiveness instead of permission. So 100%. Great. Well, that's what I got. I'm always happy to talk more metaversal type things. There's lots of other things to cover. Monetization, content moderation, all kinds of stuff that's happening in game right now. So it's definitely an interesting space and a fun one to talk about. And thank you, Rafael, and everybody else. I really appreciate it.
Thank you so much. A great panel. Guys, we want to say, Andrea, I know you want to say something too, but I just want to say how thankful I am for your time, your generosity to put this together. Very detailed presentation, great discussion. The two of you, it was great to watch. It was, I want to get into the conversation and ask questions too. Thank you so much.
Thank you, Dorian and Rafael.
You're very welcome. You're very welcome.
I thank you also, Dorian. It was very nice to talk with you about these different perspectives and about the cases. Thank you very much.
You're very welcome, and we'll see. I'm excited to see how Brazil ends up handling all of this.
I'm gonna hire you, Dorian, to work with me.
Yeah, exactly. And I can't wait to play Candy Crush with your grandmother. I'll see you.
You're gonna lose.
That's awesome. We didn't get a lot of questions from the audience. I think everybody was just glued to what you're talking, but we got a lot of congratulations on the chat. So I just extend that to you, to both of you. And again, thank you, Gabriel, for joining us, for hosting our event here. I want to thank everybody else for attending, and this was a great discussion. Thank you very much.
All right, see y'all.
Thank you.
Bye.
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 Em suas 39 primeiras edições, nosso congresso foi presencial, com grande sucesso. Veio a pandemia. O desafio de realizá-lo à distância mostrou-se oportunidade. Aprendemos a tirar partido da internet e repetimos o sucesso. Agora, para nossa imensa alegria, o pior da pandemia parece ter passado. Assim, podemos voltar a nos encontrar. E vamos comemorar isso no maior centro de negócios da América Latina, na cidade de São Paulo. De dura poesia concreta e discreta beleza. Do ano que se comemora o centenário da Semana de Arte Moderna de 1922. Frente a acontecimentos recentes no mundo das artes, como os NFTs, e frente à perspectiva de realidade virtual e a realidade aumentada virem a fundar uma nova internet, certamente teremos muito o que discutir. Como sempre, vamos tratar de todas as novidades no campo da propriedade industrial, pois sabemos que marcas, patentes e desenhos industriais ocupam um lugar de destaque no mundo em transformação. E vamos festejar a possibilidade de voltarmos a nos ver frente a frente. Depois da experiência remota bem-sucedida, quem, por qualquer motivo, não puder estar em São Paulo, não ficará excluído de nosso congresso e poderá interagir com os presentes. Todos poderão assistir a todas as sessões simultâneas no momento que convier, pois o Congresso Internacional da ABPI de 2022 será híbrido, como os novos tempos estão a permitir, e todas as sessões ficarão disponíveis na internet como desejam os nossos associados. É um novo desafio, mas estamos confiantes no sucesso. Afinal, São Paulo sempre foi palco de imensos desafios, da expansão de nosso território à independência, do sucesso de nossa indústria à grande revolução verde que impulsiona o Brasil, e da afirmação de nossa cultura e nossas artes. A fronteira agora é no universo virtual e no ambiente de negócios que nele se constrói, totalmente dependente da melhor regulação possível da propriedade intelectual. Se preparem para as discussões instigantes do Congresso Internacional da Propriedade Intelectual da ABPI. Será uma grande confraternização. Não perca!